Case number IT 9513/1I. The prosecutor versus Miroslav Radić.
Before I proceed, Mr. Radić, do I take it that you can hear me or follow what I am saying in a language that you can understand?
Da.
Yes.
Thank you. Appearances for the prosecution?
Good afternoon, Your Honor. My name is Jan Wubben, Senior Trial Attorney. At my side, you see Mrs. Joanna Richardson, lawyer, Christina Carey, lawyer, and at the very side, Mrs. Diana Bowles, case manager.
I thank you, and good afternoon to you. Appearances for Miroslav Radić?
Good afternoon, Your Honor. I'm Borivoje Borovic, an attorney from Belgrade, defense counsel for Miroslav Radić. With me is my assistant, Lea Drndić. Thank you.
Good afternoon to you too, and welcome to this tribunal. I hear this is your first time here, so welcome. We shall now proceed with the initial appearance of Miroslav Radić, and this I am doing in pursuance to Rule 62 of the Rules of Evidence and Procedure of this tribunal. Before I put some questions to Mr. Radić, I will just give a very brief outline of how we have arrived to this. The indictment against your client was initially confirmed on the 7th of November of 1995, was eventually reconfirmed on the 3rd of April of the subsequent year, 1996, and was then last amended and confirmed on the 2nd of December of 1997. On the 7th of November 1995 and on the 3rd April 1996, international arrest warrants were issued against the accused Miroslav Radić. Miroslav Radić was transferred to the detention unit of this tribunal last Saturday, that is May 17th, 2003. The president of this tribunal on the 20th of May issued an order assigning this case to Trial Chamber 2, of which I form part. And then the presiding judge of Trial Chamber 2 on the same day assigned the case to me and assigned me as the pre-trial judge. In this case, I will elaborate on this also later on, because I am also the pre-trial judge in the proceedings against Radić. Now, Mr. Radić, I am going to address you directly now, but before I do so, I will caution you that you have a right to remain silent if you choose to, although what I will be asking today is by no means prejudicial. And you also have a privilege against self-incrimination. I will be asking you some questions, and then I will also be asking you to enter a plea on each of the counts that have been brought against you by the indictment that we will be going through very soon. And that is the last version of the indictment, that is the one as amended and confirmed on the 2nd of December of 1997. So please stand up. And my very first question to you is a repetition of the same question that I asked you before. I want to make sure that you can follow what I am saying in a language that you can understand. In other words, that you are receiving a proper interpretation.
Yes, everything is in order, Your Honor.
Could you please give me your full name?
Miroslav Radić.
Are you also, by any chance, known or referred to by a nickname? In which case, could we also have your nickname?
Misha.
When were you born? Your date of birth?
On the 10th of September, 1962.
And where were you born? Your place of birth?
I was born in Zemun, a municipality of Belgrade.
What is the address at which you last resided before you were actually taken into custody, before you were arrested?
Dva Bela Goluba Street, number 10, Zvezdara municipality in Belgrade.
Now, I have an interest to know if your family, first, and the embassy of your country, of your state, have been informed about your arrest. So we will take them one by one. Do the immediate members of your family know of your arrest as well as your transfer to the detention unit of this tribunal?
Yes, Your Honor.
The same applies, I would take it, to the embassy of your country, the embassy here in The Hague.
Yes, Your Honor.
Is it your wish or desire to have any member of your family that is not yet aware of your presence here in the Hague and of your condition here in The Hague to be notified? Is there anyone else you would like to know?
No.
Thank you. Please take a seat.
Thank you.
Now, the statute of this tribunal ensures and requires that you will undergo a fair trial. And in order to ensure that, there are certain basic principles that have been incorporated in the statute itself. The registrar will be reading out to you the two main articles from the statute that relate to these rights that you have and correspective responsibilities of the tribunal and of me, myself, as the pre-trial judge. Madam Registrar, could I ask you to read out slowly Articles 20 and 21 of the statute? Thank you.
Yes, Your Honor. Article 20. Commencement and conduct of trial proceedings. The trial chambers shall ensure that a trial is fair and expeditious and that proceedings are conducted in accordance with the rules of procedure and evidence, with full respect for the rights of the accused and due regard for the protection of victims and witnesses. A person against whom an indictment has been confirmed shall, pursuant to an order or an arrest warrant of the International Tribunal, be taken into custody, immediately informed of the charges against him, and transferred to the International Tribunal. The trial chamber shall read the indictment, satisfy itself that the rights of the accused are respected, confirm that the accused understands the indictment, and instruct the accused to enter a plea. The trial chamber shall then set the date for trial. The hearing shall be public unless the trial chamber decides to close the proceedings in accordance with its rules of procedure and evidence. Article 21. Rights of the accused. All persons shall be equal before the International Tribunal. In the determination of charges against him, the accused shall be entitled to a fair and public hearing, subject to Article 22 of the statute. The accused shall be presumed innocent until proved guilty, according to the provisions of the present statute. In the determination of any charge against the accused pursuant to the present statute, the accused shall be entitled to the following minimum guarantees in full equality. A. To be informed promptly and in detail in a language which he understands of the nature and cause of the charge against him. B. To have adequate time and facilities for the preparation of his defense and to communicate with counsel of his own choosing. C. To be tried without undue delay. D. To be tried in his presence and to defend himself in person or through legal assistance of his own choosing. To be informed if he does not have legal assistance of this right, and to have legal assistance assigned to him, in any case where the interests of justice so require, and without payment by him in any such case, if he does not have sufficient means to pay for it. E. To examine or have examined the witnesses against him, and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. F. To have the free assistance of an interpreter if he cannot understand or speak the language used in the International Tribunal. G. Not to be compelled to testify against himself or to confess guilt.
Yes, and in addition to what has just been read out to you from Articles 20 and 21 of the statute, there is another provision contained in Rule 62 of the Rules of Evidence and Procedure of this tribunal, which makes it incumbent on me at this very early stage of the proceedings to satisfy myself that your right to counsel is respected. I do notice that you do have counsel here present, and I am informed that counsel has been confirmed for the purposes of this initial appearance, and we will talk about what comes later in due course. But for the time being, I am satisfied. Do I take it, Mr. Borovic, that you have indeed been appointed as counsel to represent him for the purpose of this initial appearance for the time being?
Your Honor, you are quite right. This is a nomination that I have been informed of.
So let's proceed. Mr. Radić, have you been served with the indictment in the language, in your own language, the language which you understand?
Yes, I'm just Miroslav.
Yes, I have, Your Honor.
Did you read it?
Da.
Yes, I have.
Do you understand its contents and the nature of the charges that have been brought against you?
Yes, Your Honor.
Now, in terms of Rule 62 of the Rules of Procedure and Evidence of this tribunal, you have the right to enter a plea of guilty or not guilty. You also have a right to remain silent if you want to, on each count, either today or within 30 days from today, which is the date of the initial appearance. I have to warn you that if you should you fail to enter a plea either today or within the time limit that I have just mentioned to you, then the trial chamber itself, that's me as the pre-trial judge, shall enter, in accordance with the same Rule 62, a plea of not guilty on your behalf. So that is the position. I would like to know whether you have discussed this with Mr. Borovic, your counsel, and whether you are in a position and prepared to plead, to enter a plea to each of the charges today.
Yes, spreman sam časno.
Yes, I'm ready, Your Honor.
Discussed it with your lawyer. The next thing I would like to know, or rather confirm, is that I have been informed by your counsel that you waive your right to have the indictment read out in full today, and that you would be satisfied if you are just given a short description of the various counts that have been brought against you. Can you confirm that this is so?
Tako je, časni sud.
Yes, that's right, Your Honor.
And as a consequence, therefore, I need to point out that it will not be the entire indictment that will be read out to you, but I will just read out to you the essence of the charges contained in the indictment. In other words, the essence of the various counts which have been brought against you under or by the indictment of the 2nd December of 1997. Having given you a short explanation of what you are charged with in each count, after that I will ask you whether you wish to enter a plea of guilty or not guilty with regard to that count, and we will proceed accordingly, one count after another. Your answer in each case should be a very short one. It's either guilty or not guilty, as the case may be. If you prefer to remain silent, then you can opt to do so, and you will, of course, be able to take advantage of the grace period that has been referred to by me before, but I take it that you will be entering a plea today. So, Mr. Radić, the first count contained in the indictment is a charge of willfully causing great suffering, this being a grave breach of the Geneva Conventions of 1949, punishable under Article 2C and Article 7.1 and Article 7.3 of the statute of this tribunal. If you need any explanation as to what these three articles provide, I will give you that. Do you need a further explanation, or do you take what I have explained to you as being sufficient?
Shvatio sam, časni sud.
I understand what you say, Your Honor.
Do you plead guilty or not guilty to this count?
Nisam kriv, časni sud.
Not guilty, Your Honor.
The second count against you is one of a charge of cruel treatment, a violation of the laws or customs of war, punishable under Article 3 and Articles 7.1 and 7.3 of the statute of the tribunal. Again, if you want a description, an explanation of what these articles provide, I will do so. If you don't, we will proceed with the entering of the plea. I take it that I can proceed. How do you plead to this count? Guilty or not guilty?
Nisam kriv.
Not guilty, Your Honor.
Mr. Radić, the third count contains a charge of inhumane acts, being a crime against humanity, punishable under Article 5I and Article 7.1 and 7.3 of the statute of this tribunal. How do you plead to this count? Guilty or not guilty?
Nisam kriv.
Not guilty, Your Honor.
The fourth count is one consisting of a charge of willful killing, a grave breach of the Geneva Conventions of 1949, punishable under Article 2A and Article 7.1 and 7.3 of the statute of this tribunal. How do you plead to this count? Guilty or not guilty?
Nisam kriv.
Not guilty, Your Honor.
Fifth count, again, is a count containing a charge of murder, being a violation of the laws or customs of war, punishable under Article 3 and Article 7.1 and 7.3 of the statute of this tribunal. How do you plead to this count? Guilty or not guilty?
Nisam kriv.
Not guilty, Your Honor.
And the last count, again, is one containing consisting of a charge of murder, being a crime against humanity, punishable under Articles 5A and Articles 7.1 and 7.3 of the statute of the tribunal. How do you plead to this sixth and final count? Guilty or not guilty?
Not guilty, Your Honor.
Take a seat, Mr. Radić. Madam Registrar, could you please put on record that Mr. Radić has pleaded not guilty to each of the 6 counts which have been brought against him in the indictment confirmed on the 2nd of December 1997. I am also hereby instructing the registrar to fix a date for trial when appropriate. This will be communicated to you and your lawyer in due course when applicable. I am also ordering that in the meantime you will remain in custody, and that is until further orders. I do want to inform you, however, that you do have a right to file a motion at any time requesting your provisional release. And this is in pursuance to Rule 65 of the Rules of Procedure and Evidence of this tribunal. And should you do so, I can assure you that the trial chamber will take cognizance of it and decide it with the utmost celerity. I turn to you, prosecution in this case, to remind you of your duty pursuant to Rule 66 of the Rules of Procedure and Evidence, that you have 30 days within which to disclose to the defense in a language which the accused understands all the supporting material which accompanied the indictment when confirmation was sought. Corresponding to this duty of the prosecution, you have, in terms of Rule 72 A, a 30-day period for filing any preliminary motions once you have received all the supporting material in accordance with Rule 66. Now, this is where I foresee a little bit of a technical problem, because Mr. Borovic, until you remain the legal representative of your counsel for the purposes of this initial appearance only, I have no way of instructing the prosecuting officer to hand these documents to you, because you will not have a locus standi in these proceedings until and unless your appointment as defense counsel is approved by the registrar. So I am giving notice, more or less verbal notice, to your client, Mr. Radić, of the right he has to have these documents disclosed, and the interest that he may have to ensure that he is provided with proper legal assistance to which he is entitled, both under our rules and under our statute. I am pointing this out also to the registrar, and it's almost needless for me to highlight the importance that this matter is given attention to without any delay, failing which the rights of the accused could be prejudiced. Basically, this means, Mr. Radić, that you can yourself make known to the registrar your wish to be represented without delay for the purposes of all the proceedings that will follow after today. Today it's just the initial appearance. I don't know whether you have understood what I said. You have no guarantee that Mr. Borovic will be able to represent you as from the termination of this initial hearing, unless and until something is done about it by the registrar. So it's in the interest of both of you to take the necessary actions. And my interest is to bring this out to you and make it known. At this point in time, is there anything that the prosecution would like to raise?
Thank you, Your Honor. I'd like to know that we still consider this case to be a joint case as a case against Miroslav and Radić including. It means that now in the Miroslav trial, pre-trial, there is still a ruling on the preliminary motion.
Yes.
That it means that whenever prosecution side has a plan to request this trial chamber for allowance to file a second amended indictment against Radić, including Miroslav, that we shall wait for filing a request like this until trial chamber 2 has decided upon this preliminary motion by the defense of Miroslav. I'd like to confirm this to you as a further explanation and announcement.
Yes, and perhaps we are on the same wavelength on this, Mr. Vauban. Perhaps I would better explain it a little bit in some detail, because I'm pretty sure that the defense is not aware of what happened in the past. Initially, your client, Mr. Borovic, was charged in the same indictment with Mr. Mile Mrzić, Mr. Veselin Śliwiańczanin, and Mr. Slavko Dokmanovic. You are aware that Mr. Dokmanovic is no longer with us, and that the proceedings against Mrzić were initiated roughly a year ago. I told you before that I am the pre-trial judge in those proceedings. Now, the proceedings against Mile Mrzić have been undertaken, if one reads the documentation, as if he is the only one accused. And indeed, he is the only one accused in those proceedings. But there was never a severance of the 3 accused from the original indictment. And subsequent to the initial appearance, the arraignment of Mr. Mrzić last year, on the 16th of May, if I remember well, 16th of May of last year, in order to make things clear, the Chief of Court Management and Support Services, in other words, one of the main offices of the registrar, did confirm that all the supporting materials and documents filed in cases IT 9513 and IT 9513A, and that is the indictment, the original indictment, and also the indictment that was used for the purposes of the proceedings against Mile Mrzić, shall become part of the trial records in the case of the prosecutor versus Mile Mrzić, Miroslav Radić, Veselin Śliwiańczanin, which is henceforth assigned case number IT 9513-1. So basically, for all intents and purposes of law, until there is a decision to the contrary, the case against your client is being considered, at least by me as a pre-trial judge, to be joined with that of Mile Mrzić. Now, as you imagine, it happens that today it's just your client who is present in this courtroom. So I will not say more, because one of the other accused, that's Mile Mrzić, is not present. And he will, of course, be given an opportunity in due course to say what he has to say about this. But there is another matter that was raised by the prosecuting officer, Mr. Vuben, and that is precisely that there is something cooking and almost baked in the proceedings against Mrzić, which relates directly to his indictment, because there was a request by the prosecution to amend the indictment against Mrzić. There were some of the original counts which were dropped and others which were introduced, and therefore we will have to revisit the whole matter after the trial chamber, which is dealing with the Mrzić case, hands down the decision to which Mr. Vuben has referred. For your information, this matter is being given the utmost attention by my staff, and there is one person, legal officer in particular, that has been working on it and should be in a position to provide me with the opportunity to hand down a decision without much delay. You will, of course, be informed later on of this decision, even though you were not part of the proceedings when this was being debated, and you will be given every opportunity to take the matter up as it may concern you at a later stage when that applies. Having said that, In other words, I'm confirming to you, Mr. Vubin, and I'm confirming to you, Mr. Borovic, that as far as I am concerned, the two cases will proceed jointly, unless there is a decision to the contrary. Yes, I saw you trying to attract my attention, Mr. Vubin.
Yes, Your Honor, in addition, I have two other short issues
certainly
to raise. First issue is that we would like to confirm to you that we are ready to transfer the supporting material to Radić himself, if Your Honor agrees so, and it might be the best to hand it over to him to prevent any misunderstandings. That's the first issue. The second issue is a question from the prosecution side towards Mr. Radić, towards the accused and his counsel. To be specific, we would like to know when the accused allow us, the prosecution investigators, to give us a suspect interview. Thank you.
Yes. Mr. Radić, I don't know, before I put the question to you, I don't know if you have been informed of this right that the prosecution has, and whether you have had an opportunity to discuss this with Mr. Borovic. I am not receiving any interpretation.
The interpreters didn't hear him.
Could you please repeat, because the interpreters couldn't hear what you were saying? I think your microphone was not switched on.
I'll do that, Your Honor. I have been informed about everything, but I haven't yet had time to discuss this with my legal counsel.
So what I will do, can I take it, Mr. Borovic, that you will discuss this with your client? And then inform Mr. Vubin accordingly.
If I may, Your Honor, let me say a few words regarding the joinder of the case. Of course, I will not state an opinion about that because we've only just been informed about it, but that will be no problem. Mr. Radić does want me to defend him, but we have been waiting for the formal determination of the registry so as for us to be able to know when he could be interviewed by the prosecution. And I would have to be present, as we are familiar with the rules of procedure, and I think that we will be discussing that during today. We are quite ready for the defense. We have been preparing for the hearings for some time, and in cooperation and in coordination with the prosecution regarding these deadlines, regarding the joinder and everything else, we can come to a common stand. After this initial appearance, Mr. Radić will be informed by the prosecution when he will be interviewed in the presence of his defense counsel.
Are you, Mr. Vubin? Is it reasonable enough for you?
Yes, thank you, Your Honor, and thank you, Counsel for Defense.
And there are rights of the accused related to this kind of interview, which I am sure you are aware of, Mr. Borovic, and which you will intimate to your client, which I don't need to go into now, because they do not form part as such of the process of the initial appearance. Before we adjourn, is there anything else you would like to raise, Mr. Borovic, at this stage?
Your Your Honor, I think this is quite sufficient for today, this formal discussion that we have had.
What remains for me to do is to inform you that, as has been the practice of this tribunal and as is required by the rules, I, as pre-trial judge in this joint case, I will schedule a status conference in pursuance to Rule 65 bis A in order to facilitate the preparation of the trial. This I will try to do without delay, and you will receive a communication of the exact date fixed for this status conference in due course. Before I close, Mr. Radić, is there anything that you would like to say, particularly with regard to your state of health or with regard to the conditions of your detention in the detention unit here in The Hague? If you have any concerns or any complaints, please do not hesitate to speak, because I am here to protect you too.
No, Your Honor. For the time being, I'm quite satisfied with the treatment given to me.
Any serious health concerns? Okay.
No, Your Honor.
Now, anything else before we wind up? Adjourn? I thank you all for your cooperation, and the sitting is adjourned. Thank you.
All rise. Priez vous lever.